Good morning, everyone.
Happy Pi Day.
Right? Which pie? Actually, I was going to tweet out, is it Pi Day mathematical, is it Pi Day food, or is it a G pie day?
So I think
From the
we're
FCC.
supposed to celebrate the mathematics by eating the pie. And if you can do it with a G, you've really won.
You're right. Well, welcome, everyone. We're glad to have you here at our event. I am just so honored to have the commissioner here. I'm going to read his bio for those of you that are unfamiliar, just a couple things. I know it was handed out. And then we're going to jump into conversations. At Brookings, we call this the fireside chat. So you're not on the fireside seat, hot seat, but just a chat. If you're following this conversation, we ask that you also tweet at Consumer Privacy so that we can share the love with other people who may not be with us in attendance. And the event will be taped and placed on the website later today. So before I get started, let me tell you who is sitting next to me if you just do not know. FTC Commissioner Noah Joshua Phillips was nominated by President Trump to be a commissioner to the Federal Trade Commission and unanimously confirmed on April 26th of 2018. Before coming to that, he served as chief counsel to U.S. Senator John Cornyn of Texas on the Senate Judiciary Committee. And then from 2011 to 2018, he advised the senator on legal and policy matters, including antitrust, constitutional law, consumer privacy, fraud, and intellectual property. And prior to that, he worked at a law firm, Cravath, Swaine and Moore. My sister actually worked there for a period of time. And Steptoe.
We'll talk about that later.
Yeah, right. I meant to ask you about that. He received his AB from Dartmouth and his JD from Stanford Law School. Let us give him a warm welcome for being here. All right, let me get comfortable over here.
Thank you. All right, good.
So let's start with this question of the FTC. You're there, and there's been a lot of conversation lately, so I'll just jump right into it in terms of the authorities allotted to the Federal Trade Commission. How has your experience been so far looking at the FTC as this agency that is now sort of charged with protecting the digital economy?
Before I answer the question, let me start with two really important caveats. The first is, thanks for having me here, Nicole.
You're welcome.
It's an honor to be interviewed by you, so I'm really pleased. And I just sort of, for the record, we always have to start with this. What I'm going to say today are my own views and not necessarily the views of the other commissioners or the commission as a whole. So I think it probably makes sense, to answer your question, to situate the agency a little, historically and with respect to the authorities that we have. There are two basic things that we do. We've done one of them for over 100 years, and that's antitrust law. Right. So we were started in 1915, and in the 30s, we got authority to police unfair and deceptive acts and practices, which broadly speaking is consumer protection. Right. The nature of our authority on both sides of the House is, by Congress, worded pretty broadly. And what that's enabled the agency to do over time is develop to meet challenges that are presented. And there's been a lot of development in the conduct of businesses on both sides of the House over the many decades, in fact, the century that we've been in business. All of that said, now is a really interesting time.
I was going to say, one of the reasons that it's more interesting is that P word, privacy. And so I know you are familiar, because it's something that you do every day, that we're having these really intense debates on the need for Congress to step in and implement privacy legislation, for the FTC to potentially step up their role. And this all comes on the heels of Cambridge Analytica, as well as a variety of data breaches that are not getting as much attention. Speak to me a little bit about what you think about the whole privacy debate and where you think we're headed. Is it going to be sectoral? Is there going to be a congressional law that comes out of federal law? Or is this something that we're going to debate for the next couple of years?
So the most important thing that I learned from 7 years in the Senate is not to prognosticate too much on what's going to happen in the legislature. Let me say the following. My view is that we are here because the use and sharing of data is endemic in the economy. It is everywhere. It is not just about a small group of firms. Right. Oftentimes that's how we talk about it, but little firms, big firms, across industries are using more and more data. They're monetizing more and more data. We're going to have more of that over time. Yeah. The FTC has been involved in privacy for a very long time. The Fair Credit Reporting Act is basically a half a century old, and there are a bunch of other statutes that regard privacy. And then there's that organic statute that I mentioned from the 1930s. The interesting question with respect to the legislature is, are we going to get new authority? Are there going to be new rules about how we handle data? That's something we're seeing internationally. It's something we're seeing at the state level. And in part, those processes are very much informing the national debate.
Right.
To me, and I've said this to the senators, this is the most important thing that I think we need to do as a country is take stock of where we are and decide what are the harms that we're trying to solve. Privacy is, to me at least, a fairly nebulous concept. When people talk about privacy, they can mean a bunch of different things. So you mentioned data breaches. I think one of the best things we can do, if not the best thing we can do for privacy, is have a national data breach law. If you survey people and you ask them, what are you concerned about? One of the things they're most concerned about, according to a recent study, the thing they're most concerned about is bad guys are going to get a lot of information about me. So that's one thing you might be concerned about. You might also be concerned about a lack of empowerment. I don't know what's happening to data that are collected about me. I have no visibility. That's an information deficit. Discrimination. There are all sorts of different harms. And what I want most is, as we go through this process, I want Congress, they don't have to agree on the tools yet, but I want them to agree on the harms. What are the problems that we're actually solving? And then let's have a debate how best to solve those problems. Because if you have a debate how to solve a problem you haven't defined, A, I worry you don't solve the problem, and B, I worry you create other problems.
Well, I worry that Congress actually will come up with what the harms are. You think that's a feasible solution? Will Congress be able to actually figure that out, given the disparate areas that you're talking about?
I think they can, and in a sense, I think that's what legislators do.
Yeah.
Legislators create rights, right? They can create illegality in something. They can say this is something we just want to ban, or however they structure it. Fundamentally, that's a democratic judgment, right? That's what a legislator is supposed to do. Capability, we'll see over time. In effect, they have to answer this question because they have to decide what's in, what's out. What are we banning? What are we mandating?
Right, and that should drive, just to kind of go just another layer on this, will that then drive the tools? There's been conversations around, is it opt-in, is it opt-out? What should we put as guardrails? Should we be relying on old statutes? Should we be developing, my colleague Kim Carey is here, principles around that? What do you think the toolkit might look like based on the harm?
Well, I think that's the way that you're defining toolkit, which, by the way, is the right way to define it, is the most difficult question.
Yes.
And one of the things that concerns me is we're not talking, or at least the legislature isn't talking as loudly as I would have them do about the difficult questions.
Right.
Are we doing opt-in, opt-out? What's in, what's out? Do we have a notice? How does that work? Do you have to come up consistent with international, best practices? Do you have to come up with a privacy risk assessment?
Yes.
How does that work? We're talking about things that, to me, are really important, but they're even further from the core questions. Things like preemption, rulemaking authority, fees. I think we have to answer the questions at the end of the day.
So let's talk a little bit about why we're here, though, right? So, Cambridge Analytica was one of those impetus that sort of drove us to do this. But now we see the general data protection rules that the EU has put out, and we're up against what some legislators think is the urgency to get something done at the federal level before California's Act actually is implemented. What's your opinion about both? Should we be looking at the EU, Commissioner, if you're taking some cues on what we should be putting into this federal law? Let's start there.
I think we have to look at what they are doing. I think we have to look at what effect it's having.
Right.
In a sense, we have a national opportunity, and that is Europe has done something. How's it working? One of the things that I've expressed is that I'm a little concerned at early signs that one of the effects of the law is that it's anti-competitive. And this can manifest in a number of ways. One is, very basically that compliance costs are really expensive. And if you're a big firm, you can manage that. If you're a smaller firm, that can be a little harder. Another thing is that there is, and you sort of hear a lot of this publicly, but also privately, there are vendors who stand at the ready to help you deal with this. Give your data to me at my cloud computing company, and I will resolve your problems. That may be good, by the way. Maybe that's good for data security, but it may not help with competition. At the end of the day, this doesn't answer the question finally, because what you're talking about potentially are competing values. So it may be that something is important enough that we're willing to take a little bit of competition out of the market. But my point is, we ought to do our best to know what's happening, see the effects, and see why they're happening.
Right, but what about California? I mean, that's placed, as I tell people, California's become its own country. What are we going to do with California in terms of what they're actually going to enact, which is perhaps some of the strongest privacy protections that we've ever seen?
Well, the thing about California is it's not in effect yet, so it's hard to know, it's hard to judge the impact. My understanding is there's a lot of feverish work going on in California about that. But at the end of the day, I mean, I still think it's early to evaluate the effect of GDPR. It's really early to evaluate the effect of CCPA.
Should we be pushing for preemption, though? I mean, is this a conversation that the legislature should be having, or is that something you can't answer?
No, that I can answer. I absolutely think we should push for preemption. I don't think in the world that we inhabit today, having a multiplicity of laws helps, especially with competition. You know, this is one of those areas where there are some precedents at which we can look. So HIPAA, right? HIPAA is a national law. Everybody knows about HIPAA because every time you go to the doctor's office, you fill out a bunch of forms. HIPAA, by the way, is a portability statute. Right? That's what the P is. It's not privacy. So people really ought to look at, like, how does the portability regime that we have in place today work? Most people don't even understand that about HIPAA. And in fact, doctors use it to say, oh, I can't send you the email. Not true at all. They can send you anything under HIPAA. But HIPAA doesn't preempt. So talk to the little medical firms, right? Talk to the people who are trying to make healthcare cheaper and more efficient. Does having 50 state HIPAAs, I don't know the actual number, does that help you? Does that hurt you? Again, maybe it's worth it, but it's a conversation we need to have.
Well, and that also brings up, you know, and I know I see a lot of people in here who are working on this issue, state laws, right, and state rights when it comes to any kind of federal legislation. I think that's something also California is triggering for people. States have traditionally been the ones that have enforced their own policies. There's probably 50 state laws when it comes to privacy. Will a federal law sort of strengthen the states, or will it take away from the states their ability to do their job?
Look, on some level, when you're talking about preemption, you're more in the Hamilton camp, right? I think we can say that. What I will say is that in the Constitution, right, it's the Interstate Commerce Clause to make regular, right, interstate commerce. This kind of commerce is profoundly interstate. In fact, it's international.
Right. So let me switch over to this other hot topic that sometimes gets linked with the privacy debate, which is antitrust. Now, I'm going to start by actually commenting or ask you to comment on your opinions on antitrust as it applies to other industries and sectors first, and then we'll go into the tech sector. Because I think we can stay in the tech sector for a long time, but at the FTC, you do a lot of other stuff, right? So you've spoken a little bit about antitrust with the mutual fund sector, if I understand. Can you talk a little bit about, you know, what's your opinion on that? I mean, what have you verbalized around antitrust frameworks in general? Just a moment ago, we were talking about, you know, the consumer welfare standard being an applicable framework for the FTC, still being agile enough. Tell us a little bit more.
Okay, so let me explain this to the extent the audience are filled with tech folks, what you're
exactly. And I thought, so throw a monkey wrench in there.
There's a really fascinating debate going on right now on an issue called common ownership. So actually, I'm sort of curious from the audience. If you have money at BlackRock, which by the way includes the TSP, if you're a federal person, raise your hand. Okay, and Vanguard? Okay, so in America right now, increasing amounts of money, literally trillions of dollars, are invested using large asset managers. Through all the various ways in which they hold people's assets, in the many funds and ETFs and things like that, increasingly these firms are owning substantial amounts of shares in competing companies. So, you know, United and Delta or whatever. I'm picking on airlines for a reason I'll explain in a moment. Recently, and with particular respect to the airlines, the claim is being made that the fact that these large managers own substantial shares of competing firms is having an anti-competitive effect or a price effect, meaning that it's leading firms to compete less. And the theory is basically that your biggest shareholders don't want you to compete because they would benefit from non-competitive kinds of conduct. That's how you as CEO are going to behave. It's like a fascinating area of debate. The debate kind of went like this. Early papers showing some really interesting things done by economists. Hot minute, lawyers proposing drastic changes in how our financial markets work. I'm concerned about that jump. What I want, and what I've said publicly is, I want us to continue to do the research. I want us to learn, is this right? Are we seeing it in other areas of the economy? How does this mechanism work? And then get to the policy solutions, not jump to the policy solutions based on one paper.
So I say that because that was your first speech. So now you're at the commission a little bit more our time, right? Now the whole thing is big tech. When I was at South by Southwest recently, Senator Warren came out and said big tech should be broken up. There's been a lot of conversation around big tech companies and antitrust violations. Help us explain, based on your experience now and what you've looked at with the mutual fund industry, how should we be looking at this sector, though, as well? It's the same kind of thing, same framework, or what?
So I think the framework is the same. The law is the law.
Yes.
Antitrust law is, for the most part, not specific to any given industry, and it's developed over time. I think the reason there are a lot of reasons the tech sector draws a lot of attention. The companies loom very large, as a matter of fact. They loom very large in the public's imagination. They're very disruptive. And in particular, they're very disruptive of a lot of competitors, right? So a lot of business models are being upset. And that's part of why we're having such a loud conversation.
Yeah, but when we go back to privacy, there's been conversation too, Commissioner, around, well, maybe we should place privacy as one of those indicators of antitrust violations. Are you one of those fans of that thinking, of that line of thinking, or is that something we should totally keep separate in our conversations around this?
I'm not a fan of that kind of thinking. One of the things that I worry about in grouping too many concepts together is it leads to a lack of clarity. So I don't know what to do. I don't know what the rule of decision, there's an old philosophical principle called Borodin's ass, and he's a donkey, and he's got two equally sized piles of hay, and they're equidistant from him, and he can't decide which pile to eat, and he starves to death. And the principle is meant to illustrate that if you have goods that are non-reconcilable, or different values, trying to choose between them is really hard to do. So that's for the law enforcer. For the company trying to decide whether their deal is legal, how do you reconcile that? How do you plan in advance? And as a corollary matter, I worry that it gives too much discretion to people like me.
Yeah, and I guess going back to that, the chairman of the FTC wants more rulemaking authority, though, around that area. Do you agree that there should be more rulemaking at the FTC? So that you can actually look and see what part of the donkey's is actually good.
Which pile of hay?
Yeah, which pile of hay?
So that, to me, is part of the privacy conversation. And what I think about rulemaking is that, and it goes back to what we were talking about earlier, I think the fundamental democratic judgments need to be made in Congress. I don't think you want to give 5 people or 3 people the authority to legislate. The first is for democratic reasons, like we're not elected.
Right.
The second reason is what you don't want to see, especially with rules that potentially impact so much of the economy, is changes over time. Whatever you think the rule ought to be, what you shouldn't want to see is every 4 years or every 8 years or even some other period of time, dramatic shifts in what the rules of the economy are. That's really hard for firms to predict and to plan around.
Well, there was recently an announcement of the FTC putting together that new commission, right, on big tech and competition.
Task force.
Yes. So do you think the FTC actually has a natural inroads into enforcement then, maybe based on the, like you said, the big umbrella of really determining what it is that you're actually looking at? What's the problem?
So the task force, just to be clear, it's not a privacy thing.
Yeah, it's a competition,
it's a competition
right?
thing. Exactly. So, to me, what the task force is about we all marvel at some of these firms and the technology industry. And some of, I don't mean marvel as like a positive necessarily. Maybe awe is the right word I'm looking for. There's a lot to look at. And what you want to do, you want to look at the firms, you want to look at the practices, you want to look at what we do, our processes, and most importantly for us, are we thinking about competition the right way? Let me give you an example, which to me is a really interesting question, maybe the hardest question we deal with. A lot of the firms that a lot of folks are talking about benefit from what we call network effects.
Yes.
So, the sort of curve of use goes up in such a way that it can be winner take all.
Right.
So is the competition like other firms that don't compete in that way further on down the line, or is there an earlier point of competition that deserves more attention? The task force is part of thinking about those kinds of questions.
Right. So I want to go into, and we're going to be taking questions in a moment. Again, follow our conversation on the hashtag consumer privacy. And if you have questions for the commissioner, I'll be opening up the floor in about 15 minutes. I'm just taking moderator privilege and asking some more questions. So let's talk about emerging technologies, just as a flip the script here. A lot of these tech companies are actually in the space of artificial intelligence. We at Brookings are actually involved with that. The FTC has traditionally been involved in algorithmic bias. Previous administration took that as one of their areas of interest. And I actually did a big data workshop 5 years ago talking about big data, and now we call them algorithms, right? To a certain extent. As we think about algorithmic bias, and we have a paper coming out here at Brookings on that, should the FTC be taking a more active stance with this? I mean, we're seeing people get denied loans as a result of algorithmic bias. We're seeing higher education decisions be made, bail and sentencing decisions being made that disproportionately affect protected classes. Curious as to your thinking, is this a privacy issue again, or is this something that might be in its own bucket by the FTC to ensure, there's no deceptive practice or discriminatory effects?
Well, let me say this. It's not unrelated. We actually, I mentioned FCRA, the Fair Credit Reporting Act.
Yes.
This is a statute, which we've had on the books for a long time that can be applied to this. There's a recent case that people can look up called RealPage. We had a company that provided a great product for people who wanted to rent apartments quickly to evaluate the person who wanted to rent the apartment. But the results coming up weren't so great, right? And we entered into a settlement with them to improve sort of what they do and find them money. So there are already tools at our disposal to help deal with that. I think it does need to be an area of focus. I think that's right. I also keep in mind though, and this is so funny for things like the extension of credit, because I don't think anyone should nostalgize the old world of credit, where it's like, you and I play at the golf club together, and you come into my bank, and I know you, and you're a good person. Not sure that biases didn't impact that process. So there's promise in using objective metrics. There's promise in using AI, but we have to look out for where it has bad effects.
And is there also this conversation, because some of these technologies are still nascent form, like facial recognition, et cetera, should we be trying to figure out ways to balance that innovation before we prescribe rules over these things? Or it seems like everything we're talking about still has time that we have to look at these things.
Yeah, look, I think we have to keep in mind the U.S. remains fundamentally a very innovative economy. That's a good thing. We want to encourage that. It doesn't answer all the questions. We also want to understand what we're purporting to regulate. We want to weigh the costs and benefits.
That's right. Now, I would be remiss if I didn't ask you this question as well. When it comes to algorithmic bias, will the FTC also be looking at conservative bias, like political bias? As it's a non-protected group, but clearly it's gotten a lot of conversation on the Hill. So I'm actually also curious, while you're sitting here, if that's actually going to be a scope of interest to the FTC.
So I've tried to say this on the Hill. I've tried to say this in public. I don't think we should be involved in that business. One of the things that scares me as a public official is the notion that public officials should be looking at which opinions are getting what kind of treatment in the market, and then trying to correct that. I think that gets you into really, really, really dangerous First Amendment waters, and I don't think we ought to be there.
Yeah. So let's switch modes for a minute, because I know there's a whole lot more that you do at the commission than what we're talking about, and it's actually worth probably having a discussion on that. I know that you recently spoke about non-compete agreements, and curious to, one, explain it to the group why that's an important area that you took on, and what your perspective is on those.
So just to be clear, I haven't even spoken on this yet. I did. It found its way into some testimony.
I was going to say.
So non-compete agreements are something that one finds in the economy. They've traditionally been understood as a mechanism that a firm uses to make sure that it retains the incentive to train, to protect trade secrets, things like that. So, I'm trying to think of an example. You go to a tech firm and they say, you can't go work with our competitor or our competitors for some amount of time.
Right.
Very different state regimes in the United States. Interestingly, California, very suspicious of non-compete agreements. California also happens to have a lot of innovation.
I was going to say.
And this has not escaped the notice of a lot of policymakers. To me, the issue of non-competes falls into a set of issues that relate to a broader, like a real issue in the United States economy right now, and that is labor mobility.
Yeah.
So for years, the FTC has done some of the best work on issues of occupational licensing. Barriers that states erect, legal barriers to entry that prevent people from starting new businesses. Sometimes that's important for health and safety, but sometimes it's not so good. Sometimes it's people protecting themselves or their friends through use of legal barriers, and that can be really anti-competitive. In 2016, the DOJ and the FTC got together to do HR guidelines. And one of the things that came out of those HR guidelines is a great initiative that they're doing over at DOJ, and that's to look at what we call no-poach agreements. So that's firms that agree not to hire each other's workers. What we are also seeing in a lot of the academic research is that non-competes are much more prevalent than at least we thought they were. I don't know if they're more prevalent than they used to be. And they're prevalent in areas of the economy where we might not expect them, like fast food workers, where you're not thinking about like them stealing the client list or the IP or what have you. To me, these three issues, occupational licensing, no-poach agreements, and non-competes, together inhibit the free flow of labor. They inhibit the ability of workers to bargain for what they're worth. And I think policymakers in general ought to take a look at that. I will say, from an antitrust perspective, a particular non-compete agreement, it's often hard to see how that becomes an antitrust case. But if you look on the Hill, people like Marco Rubio are taking a really close look at this from a policy perspective, and I think that's the right thing to do.
And as it relates to the tech sector, would that have an impact there, or it seems like it could actually?
So labor mobility in the tech sector is like a fascinating story over time.
It is really fascinating.
As I mentioned, California traditionally has been really hostile to the non-compete stuff. And some people attribute the innovation to that. So my inability as your boss to keep you from going to the competitor allows you to move around and share ideas. Now, we don't want you to share trade secrets. But sharing ideas and ways of thinking about something can really foster innovation. California is also the place where DOJ brought a case a few years ago involving some really big firms doing this no-poach stuff.
And that brings me to this last question before last. Again, I will open it up to questions from the audience. Should we be looking at, or the FTC be looking more carefully, though, at these labor issues that are associated with the sector that we just discussed? I was just on the Hill the other day talking about diversity in the tech sector, talking about, all the implications of this growing part of our economy. Is this a concern that the FTC should be taking on?
So something that both the chairman and the head of our Bureau of Competition have talked about looking at increasingly is the issue of labor monopsony. To what extent, for instance, a merger might have an anti-competitive effect on the demand side for labor. So it's something we are taking a look at.
Yeah, no, that's good to hear, because I think that just different demands, different economies have different scales. So before I go to questions, I do have a question to ask you. So what's going to be your legacy? You're there. Sounds like you've got a lot of things on your plate, but what do you want your legacy to be as a commissioner?
I think what I want more than anything is to do my best to make sure that the policy we push and the cases we bring are like well-grounded and well thought out. there are a lot of people talking about the issues that we deal with right now,
Right.
more so than I think I've seen in my lifetime. And in a sense, that's really good. But I just want the conversation to be grounded.
Yeah.
That's, I think, the most important.
So if you
thing for
become
me.
the grounded commissioner, you'd be happy.
Boring is what I do.
Right. Now, the commissioner said before it came out, I'm not sure how lively, but you've been great. I mean, the conversation has flowed. We could sit here and talk for hours. That's why we call this a fireside chat. He's almost like in my living room having conversation.
Some living room.
Yeah, no, it's a big living room. I have a lot of guests. So I actually want to open it up for Q&A so we have enough time. I know the commissioner has put out a lot of information, and it's always great to have them in person. So we have a microphone coming. We'll start with the gentleman in the middle, and then we'll go to the gentleman here. And then I think I saw a hand over here.
Hi, it's Mark McCarthy with Georgetown University. Great conversation, good questions, great answers. So can you give us more reaction to Senator Warren's tech proposals? In particular, her ideas that some of the tech mergers should be unwound.
Let me say the following. One of the things I was talking about in the context of privacy a few minutes ago was the notion that we ought to line up the remedies that we apply, the sort of tools that Congress gives us, with the harms that we perceive. That principle of aligning harms and remedies very much exists in antitrust law and ought to do so. Meaning, when we block a merger or require some sort of remedy, or when we pursue a conduct case, right? We're going against an anti-competitive thing that a company is doing. We ought to pursue remedies that are tailored to the harm. The breakup of a company, divestitures happen all the time in merger review, but the breakup of a company isn't something that is all that common in American history. And the reason for that, there are a number of reasons for it. One of it is, in a sense, it's sort of like the starkest remedy. In another sense, it's really hard to do and complex. It's not so simple, oftentimes, as just as an outsider, or even as a regulator saying, just take that and move them apart. There's all sorts of complexities, and there have been historically decades of litigation over these things. I think that the question always should be, what's the harm at which we're aiming? How does the remedy address the harm? Different firms have different businesses. If you're just talking about the same remedy to address the same perceived thing and you're not even differentiating the businesses, I worry that you're missing some nuance.
Next question is right here.
Hi, good morning. Thanks for being here. Dave Pereira from MLEX. You've said many times that remedies have to match the harms when it comes to privacy. Could you take a stab at what your perception of the current privacy harms are, specifically?
Sure. So let me pick off one in particular. Let me back up for a minute. One of the interesting things about the privacy debate is the degree to which people don't agree on that. Which is why I think having this debate and having the democratic process decide which harms we're going to address and which harms we won't is important. I said before, one of the best things we can do for privacy is deal with data breach. I think people largely view...
What's the remedy?
No. My data being, unwarrantedly disclosed to other people, I might very well think of as a harm. I might spend time and money to deal with that, right? But figuring out, do I have to call the credit bureau? Do I have to freeze things? That's a cost. The worry of thinking, oh no, a bad guy. So I think that is harm. Another example, I think there's a very good argument that there's something of an asymmetry in information in the market between consumers and firms about what is being done. So I think thinking strongly about how to give consumers more information is something we really ought to do.
And would that be like that transparency effort or whatever's in that transparency toolkit would actually be a remedy for that particular harm?
Potentially.
Yeah, and I mean, I totally agree with you just on that moment of the data breach. The work that I do here at Brookings deals with historically disadvantaged communities a lot and vulnerable populations. And the greatest asset that they have is their social security number. And if you think about those populations compared to those of us, I mean, I've had my credit card hacked multiple times, but I could easily go to another credit card. Person who has their social security number hacked, that's it.
That person also probably has a schedule
Yes.
that doesn't allow them to spend a lot of time
That's
on
right.
the phone with customer service,
That's
right?
right.
They've got to pick up their kids. Maybe they have to pick up somebody else's
That's
kids. So yeah, these little bleeds of time can have a
Yes.
real impact on people. And I do think,
That's right.
as a general principle, you want to focus on the areas of the greatest harm first.
Yeah. So you think it's, just want to piggyback on this gentleman's question, do you think it's worth then doing a grid that has these harms sort of explicated and then a remedy toolkit as a result of that? That's a different way, I think, of a methodological process for the debate that we're in right now. Could be.
Yeah, no, I think that's a great idea.
I
Right?
know,
And then
something
we can
came
debate.
out. Cam, you hear that?
We can debate. Like,
Exactly.
does the remedy address the harm?
Right.
Does it outweigh its costs?
Yeah, I looking at my colleague Cam Carey, we might have a paper here with regards to that because I've not heard that spoken about in a way that you've sort of laid it out, which could get into the details that I think many of us are struggling with right now. Next question. Okay, who's got the mic? That's interesting.
Hi, I actually had a quick follow-up on that topic right there before my main question, and that is, do you think that the FTC can move forward with harms without a dollar quantification? Because I know that the FTC privacy con that has been going on has been focused on asking academia, which is where I come from, over and over again, can I put a dollar amount on privacy harm? Can I do it? Can I do it? And the answer has continuously been, we don't know how. So can you move forward without dollar quantification?
So it's a great question. And one of the most interesting things to me is the degree to which that was like 2 years ago a really big debate. Now, in the context of this privacy legislative forum, it's sort of, people are not focused on it. We have historically, even under Section 5, right, where you have to show substantial harm, we've looked at things that I think don't all align with out-of-pocket loss. So reputational harm. Although there was sort of more economic harm as well. I'll take an example, the whole thing is unfortunate, the Ashley Madison case. This is a website where people will go to cheat on their spouses, in particular men go to cheat on their wives, and they promised really good security. And they were breached. So I don't have infinite sympathy for the victims, but there's no question they wanted to keep that private, right? So I think we have at the margins, but the really important question for purposes of the privacy debate is, in my mind, almost any way this shakes, if it ends up in legislation, you're going to be in a world where you're addressing precisely those kinds of harms. Now let me say the following. There is nothing particularly out of the ordinary about Congress saying this is a harm and you should have a remedy, however that remedy looks. Like, that is a perfectly plausible thing. But I do think, in a sense, that debate, which is super important, and loomed incredibly large like 2 years ago, has been superseded by this debate about which harms are we addressing, many of which are non-economic.
That's right. That's right.
So, sorry, my actual question was actually going right up on that.
But I liked your first one.
I was an FTC intern. So
Where?
the next one is, so you said that fundamental democratic judgments should come from Congress versus coming from the FTC rules. A good example for when there's an actual need that Congress isn't filling, especially when Congress is moving very slowly like it has the last couple of Congresses, is COPPA, where there are maybe not quite defined harms happening, but there's an understanding that harms are happening even if we can't define them, and a rule needs to be made because there is no congressional, step in to protect, and COPPA, for those who don't know, protects children and children's privacy. Thank you.
So Well, I'll start with this. We have done rulemaking on COPPA, and I think Congress ought to look at that process and what people said around that process. I think that's like I was saying with respect to HIPAA earlier, I think that's a really important way for Congress to learn about how we have made rules on privacy in the past. Personally, especially as a parent of 3 children, I'm a paternalist when it comes to kids.
Right.
Kids, though, are not the whole population, right? So COPPA also addresses an area, I think, consistent with the regime we have now, which is a risk-based regime, where Congress has stepped in and it said, look, that's an area that requires special protection, right? Kids, health information, financial information. It is not shocking that we have the scheme that we have today.
Right. Actually, I wanted to, moderator privilege, go back to her first question, though, because you had me thinking about something, and then we'll go to the next question on monetization, right? So there are conversations that are happening about consumers owning their data and giving it a value, right? And so it's sort of an input-output. If you quantify harm, should we also have the ability of consumers to quantify the value of their data as well?
So
there's a lot of talk about that going on.
There's a lot of talk about that. I need to learn more. Let me start with that. I'm not enthusiastic about that concept. I find it analytically really difficult. I also really wonder, especially as a lawyer, you create a property right in something that is shared everywhere by lots of people and has a value about which we can quibble a lot. What effect does, with rights come remedies, right? Lawsuits. Like, how does that look? And I have not been sold as that as a metaphor. You know, it's tempting to think of it that way, and there is no question that when firms collect data about us, there is a value to them. What the value is from our perspective may be very different, even of the data that they collect from us.
Right.
Because they can use AI, right? They can use big data to imbue it with more value. And that's what firms do across the economy in a variety of contexts. And to some extent, you know, this is part of the debate we're having. Let's not forget the fact that consumers already derive quite a bit of value, right? So you get a lot of good things for free. Now, I think people are, the nation is in the process of evaluating, well, how free is free? I'm sorry, when I say free, I mean not out-of-pocket cost. Is it really free, and is it worth it? Those are fair questions to ask. But it is certainly not true that on the other side of the ledger, there are no benefits for consumers.
Well, I mean, that's the internet was, for those of you, a history lesson, right? The internet was based on our free exchange of data, which is why we have an ad-supported model that supports all the great things that we do to a certain extent. But that's an interesting question because, again, I think people are starting to think I have this natural resource should be evaluated in such a way that I'm able to sort of control that. But it could also stifle innovation. So,
you know, there also is a sense in which, sorry to interrupt, Nicole, but you know, the market can take that into account, right? I'll be interested to see to what extent are privacy-driven business models popular.
Right. And that goes back to, I think, the young lady's question in terms of the children's protections. Perhaps federal legislation should use those as sweet spots to focus on. You know, obviously, I don't think any of us want to evaluate our health data. We want that private no matter what, right? And we don't want to barter that as some kind of trade, potentially.
We don't want to barter, but let me pick on that, and this is something I've been thinking about increasingly. Just my personal experience, and this is not a good way to make public policy, I'm not convinced that there's really good sharing of health data going on.
It was supposed to happen.
That was what HIPAA was supposed to do,
right?
and instead, for a lot of people, it works as an impediment. And you know, you don't want your data breached, and maybe you don't want ads predicated upon it, but do I want my primary care physician to talk to my specialist? I do. And you know, our choices in healthcare are governed by a whole, you know,
and I think
complicated scheme.
I mean, we could have a whole conversation on this because I just think, like, you know, do you want people to say, oh yeah, for 25 cents, take this part of my healthcare record and all that? And I think that's a difficult conversation that people aren't getting to the weeds of when we actually talk about this new commodity.
But I'll give you an example, and just to be clear, like the FTC doesn't even do HIPAA, but you're getting a certain kind of treatment. And let's say you're dealing with 2 or 3 different doctors. Unless things are really going as planned, and they often don't, it's you, maybe sick, talking to different people and trying to convey the same story. The fact that you forget a material detail in one conversation can have a real difference.
Yes, yes.
Like, there is a world of data sharing that helps too.
Yeah.
And that's just something important to keep
Yeah,
in
no,
mind.
thank you for reminding of us. Okay, so I completely lost track of who's next, but I think it was this gentleman right here in the green jacket. I'll go there, and then Marita will get you third. I'm sorry, before I go there, this gentleman way in the back, because I do have my glasses on and I can see you. We'll go here to the gentleman in the back, here, and then to Marita Coley.
I have a question about rate of progress. One of the privacy-related issues are the innumerable spam phone calls we get every day imitating other phone numbers, and often they're out to fraudulently take money away from people. FTC has been addressing this, I don't know how many years, the only remedy was file a complaint with the FTC, which every month gets more complicated to do. And you have this long list, but I have seen very little progress in implementing the very well-known technical solutions to this problem, which just don't allow people to create a phony telephone number.
So, in my own life, and certainly when listening to people talk about what we do, this issue might loom largest.
Right.
Because you're reminded 5 times a day that whatever it is,
Right.
it isn't working.
Right.
We have been and will continue to bring cases under the telemarketing sales rule to enforce the authority that we have. But part of what you're seeing in the market is that the cost of internet telephony is zero. I mean, it's nothing. And the technologies are spreading. It can even reach from without our jurisdiction. So it's not a problem that enforcement alone can solve. So that's why you see 2 really important trends that I hope provide great promise. One is what we've been fostering, which is competitions to develop technologies on the user end to help people identify or at least not take the call, right? So we held a contest. You should go to our website. There's a bunch of apps that can help. It's great that that's spreading. I know that telecommunications firms are working, it's called like shaken and stir, on protocols that help. I think that has to be part of the solution. But it's terrifically annoying. It's terrifically costly. I mean, I pick up the phone twice a day, and it's a Chinese person talking to me. I presume they don't know me. Certainly, I don't speak Chinese.
Right.
Look, I think it's P.J. O'Rourke, I might have this wrong, who said that the do not call list, which was Chairman Tim Muris's initiative during the Bush years, was like the greatest public policy achievement since the Elvis stamp or something. I think if we could solve this problem, we all would do it. The problem is a lot of what causes the problem isn't something we can just whack. We're going to continue to whack at it, but I think it needs to be a broader kind of effort.
Yeah, isn't it interesting? The old communications protocol still has a big looming problem because we can't actually stop that. Okay, this gentleman in the back.
Hi, Jeff Zerbrugge with Walmart. I really appreciate the conversation today. A lot of the topics we've touched on today so far have also been included in the FTC's 21st century kind of privacy and competition review. Could you touch a little bit on the learnings to date that you've seen? And at the conclusion of that in the coming months, what are your expectations for activity from the FTC in terms of reports or other things, and any ideas of what you expect the conclusion of that to look like? Thank you.
So I'm more or less going to dodge the answer because we have taken in so much learning, and everyone is still going through, not only the people who are on the panels, which, by the way, are still ongoing, as well as the comments that came in. Broadly speaking, this is a process of, where are we? Taking stock of current learning. It's all modeled on this effort in 1995 by Chairman Petovsky, which led to some really important improvements in how we think about IP and antitrust, how we think about efficiencies in antitrust. And it's absolutely plausible that there are innovations that come out of it, but I think it's a little early to tell.
There's a question here.
Hi, thank you. Charles Cutchall, a member of the Brookings Society. And taking a step back and thinking holistically about consumer privacy, regardless of your permission, your views on the privacy rules that came out of the FCC and what happened to them, do you think that we need to consider the rules of the road for telecommunications companies, which are essentially the highway system by which our information transits every day? And also, do you think that thinking about consumer privacy and not considering perhaps a refresh of the way that the federal government handles individuals' information would be a missed opportunity?
Sorry, repeat the second question again.
Sure, absolutely. A lot of the conversations that I've seen, a lot of bills coming out of the Hill, tend to really focus on technology companies and the role of the FTC. And I was wondering if you had any thoughts on whether or not there should be a conversation taking place about perhaps some of the outdated privacy protections that we have in the federal government. Privacy Act of 1974, for example,
Right,
the
which
key,
regards the
key word
government.
being 1974 there, date. I'm just interested in your thoughts and just in terms of a more holistic approach to privacy.
So the short answer is yes, right? And the reason the answer is yes is because the economy has developed in a way that is leading to this very conversation. With respect to your first question, should we think about telecoms? My sense is that we're thinking about everything. The telecoms are really important. The consumer companies are very important. The data brokers are really important. There are a lot of different areas. What we need to be thinking about when we talk about privacy, in my view, is the fact that it is not just a small set of firms. Right. Like, this is not just a conversation about a few companies that each of us deal with every day online. There are thousands and thousands and thousands of firms dealing in your data, using your data in really beneficial ways. Maybe they're using it in ways that you don't love. But any way you slice it, with respect to a particular person's preference, the point is that rules can have really broad impact, and you need to think about that impact.
So you think there, just to follow up on that question, so you think there should be a comprehensive privacy approach versus something that's more sectoral, or should we still keep emphasizing, like you talked about with healthcare or the financial service industry, some points that actually apply to those sectors as well?
So as I said before, to me, like, I like to focus on harms.
Yeah,
What
so
harms
figure
are
out the
we
harms,
addressing? I think that part of why we're having a broader debate now is that people are beginning to see that the firms that deal in what they might view as sensitive data are much like more myriad.
Yeah, because I think the question that this gentleman has is, there was interesting, and that actually was related to the institution of the net neutrality rules, that there needed to be a greater use of that section to enforce it against telecom. But what we've later found out is that I think most people are looking at being platform agnostic and technology agnostic, saying, hey, we need a comprehensive framework to actually move forward. So it's interesting. Okay, Marita, you had a question here, and I'll take this young lady in the back, and then we'll start wrapping up the event. This is good.
Hi, Commissioner Phillips. Rita Coley from Multicultural Media, Telecom, and Internet Council. You indicated earlier that we should be pushing for federal legislation that preempts state law. Based on some of your experiences in other than privacy, can you sort of drill down on that a little bit and help us to understand why that's important, and which we agree to, but I just wanted to understand that.
Sure. So I'll give you a one-word answer. The reason is competition. Where you have regulations of any kind, one of the impacts that they can have is a barrier to entry. Compliance costs money. Compliance on these kinds of issues can cost a lot of money. I'll give you an example. So in GDPR, there are certain rights about accessing your data and correcting it.
Right.
If you are a firm that hasn't been collecting data by person, you have to figure out a way with whatever databases you have to link the data you have collected to some sort of identifier. By the way, I'm not even sure that process is great on its own for privacy,
Right.
but it's certainly expensive. The more different schema you have, the more expensive that will be. And that hits smaller firms harder. So I think for me, preemption is a mechanism to make sure that when you start your company, or even if you're dealing with a company that didn't realize it was dealing with data before, or just wants to monetize the data that it's had for years, you're a small firm, you don't have to hire tons of lawyers. When you are a startup and you have 5 people, one of them should not be a lawyer. But we should all, I love lawyers. I am one. I come from one. But that's not the best way for us to innovate. So to my mind, having one standard is a really good idea.
Yeah. Before we go to this last question, I do have to ask this one question. We've been talking a lot about domestic, and I said I would ask this question. International, where are the conversations around global governance around privacy, international frameworks, data portability, sharing? That conversation is still going on, correct?
Oh, yeah.
Yeah.
So I was just a few weeks ago, I was in Santiago, Chile.
Yeah.
This is the meeting of the APEC, the Asia Pacific Economic Council. And one of the issues on the table is portability of data.
Yes.
As different countries develop different standards, the growth, the economic growth we've had in the economy can be inhibited by the fact that you may not be able to share data. American firms spend a lot of time worrying about these issues. To me, the most important thing is however different states resolve their preferences with respect to privacy, and people will have different rules because they have different traditions and preferences and so forth. We ought to find a way to interoperate.
Yeah. And should we have some, and as we prepare for this last question, should we have some guiding principles that apply across countries? Because it seems to me that the way that we could probably find ourselves in a patchwork of privacy rules is the same way we could actually go globally. There are some things that we have like Privacy Shield, et cetera, but I'm not sure where the international conversation is going with this.
I mean, I'm not sure either. I think the Europeans very much want to take what they've done and spread it to the world. I don't think that's the only model. What I think, though, is critical is whatever result at which a particular nation arrives, that we still be able to have, all share in the benefits of the economic growth that we've been enjoying.
That's the key. All right, last question, and then we will wrap up and thank the Commissioner for coming.
I have personal information on the internet that I have never posted, published, or authorized, but is impeding my efforts to find a job. And the FTC said they could remove that, but Congress hasn't given them the authority. What would it entail to have a do not post, do not publish list we can put our names on, and the list itself would be hidden, but the personal information would not be able to be put online? Is that feasible?
The short answer is I don't know. In Europe, something you hear about is what we call the right to be forgotten. In the states, that may raise First Amendment issues. But I will say, just to sort of echo your point, I have hit times where I have found, now I'm sort of a public official, but I found data about myself online that I was very surprised to see. I think that's one of those things where the reason we're having the conversation we are on privacy now is because people are experiencing things like that, and they're saying, wait, what?
Right. Well, I would actually just leave us with this thought on the right to be forgotten, to this young lady's point. So I was at South by Southwest sitting on a panel hosted by a group called LGBT Tech. And we were talking about encryption, and somehow the GDPR always comes up when you talk about privacy. But someone asked a question, just something to think about when we think about the right to be forgotten. No, in this country, you can't be forgotten as a sexual predator. Your credit report has certain guidelines on the Credit Reporting Act. But someone asked a question about my gender fluidity and my ability to sort of recurate my identity under a clause of right to be forgotten so that I'm no longer identified as the previous person I was. I'm still that same person, but I'm actually different now. And so I would just put it out there more as a comment. It maybe put my aha light on to say perhaps there are scenarios and circumstances where it could be interesting, to apply a right to be forgotten, particularly since America has changed. You know what I mean? So I'm not asking you to comment on that. I just wanted to put that out in the universe because I said I would come back to D.C. and say it at some conference or panel. And I found the right one, and thank you for actually bringing up that question. But it's something to think about for those of us that have carefully looked at what could be applied in the U.S. and the GDPR. Gender fluidity is obviously one of those topics that has made a real inroads in our country in terms of how we look at people. On that note, I will say thank you, Commissioner, for actually coming. Let's give him a round of applause for his participation today.
Thank you for having me.
It was good, right?
Thanks for watching. Be sure to like and subscribe for more videos from Brookings.